ladies and gentlemen, I'm sorry for the complications. I can obviously do it without the presentation. Hopefully it will work soon. For the starters, as Vlado introduced me, I'm working for the university. I'm doing their PhD. I'm head of legal department of technology transfer office, and I also work for faculty of informatics as a lawyer for Center of Excellence for Cybersecurity, cybercrimes and things like that. So the lawyer for information technologies, new technologies, and that's why I'm going to hopefully talk about software protection, which is really a specific, it's really complicated, and it shows that the law is a classical tool which can't comprehend new technologies. All the protection was historically quite difficultly developed. The lawyers didn't understand the technologies, and they introduced the regime which does not comprehend to the actual needs of protecting software at all. And that's my first point to talk about. The second part, I was asked to say something about who owns the software. If you are working for employer, if you are working for your own, what can you do with your software, or who decides what will be done with the software? The third part, if we have enough time, is focused on the licenses, on open source licenses, because it's quite an important legal tool, how to use someone else's software without basically granting direct license from him. So this is it, and still no presentation. Maybe can I ask someone, does anyone have any other computer? Because obviously mine is not working, as we didn't expect it that, and I wanted to show you some paragraphs and things around. So hopefully some more minutes, and we will see. Yeah. Anyways, not to be silent. I was asked how long my speech will be. I was saying something between 15 minutes to 4 hours. It depends on you guys. I wanted to make it really short and quick, so well, maybe the presentation will be offered for you, so you can see some definitions by law, how the software is protected. But I will just start and try to catch up with the presentation. The first point is that there is a software protection, or generally the protection of author's work, because we are talking in this sense about author's work, and it's included in Copyright Act. It's included in Czech Copyright Act in the beginning. It's basically saying that all the creativity of the authors are protected, which also includes software. I'm talking about Czech law, but basically what I'm saying, it's really similar to all the European law, because the regime is harmonized on the level of software directive on the international level. So basically, if I'm talking about Czech Republic, I'm talking about EU countries, and partly also about US, Canada. The regime is somehow similar to that. Back to Czech Copyright Act, in the beginning it's saying that the software, or better said, because the code is using the term computer program, it's saying that it's author's creativity work, and it should be protected. This is all it's saying in the beginning. Nothing else is said, like how it's going to be protected, which tools we are using, and so on and so forth. We have to go down the code and trying to find better definitions. Oh, something happened. Voila. The main definition and the main software protection is saying that the software is protected as a literary work. What does it mean? And this is really the core, and this is really the problem. This means that the code, the text, is protected. No functionality actually of the software is protected. It's just the code, one by one. This is really the problem, because I don't see the core of the software only in the text itself. It's just a tool. It's just a tool how to make the software working, right? It's not expressing what all the software is about. It's it's not expressing the ideas, the software designers who are not creating the code itself, and that's probably the problem. On the other hand, the directive and also Czech Copyright Act and other copyright acts are saying, okay, the software is protected, and then also preparatory materials are somehow protected. So basically, if someone is creating the software and wants to protect not only the text itself, but also the ideas behind, he should put it on the paper. That's the first hint for you. If you are doing something and want to have the protection, you should put it somewhere in the materials, in documents around the software. Because again, Copyright Act is saying that it's not protecting ideas. It's hard to protect the ideas because it's in my mind. And one of the signs of author's work is that it's objectively comprehensible by the audience. So somehow the idea has to be put on the paper or presented actually to you, or if it's music, then played on the piano or whatever else. But it can't stay only in my mind. And here we are. Thank you very much. So I will try to catch up with my presentation. I had some nice pictures, but we are too far. And this is it. What I was saying and what I was trying to say is that the software is really, in the moment, protected on the first level as a book, for example. The problem is, and what is not protected, it's the functionality, again, repeating, and the ideas. This was actually confirmed, and especially the functionality was confirmed by European Court of Justice, European Court of Justice, whatever, saying that the functionality is hard to be described, and we can't protect it at all. The idea is, if the functionality would be protected, imagine that you have Microsoft Office. Everyone knows Microsoft Office, right? Functionality is to create the text documents. Then we have LibreOffice, which is basically looking the same, doing the same thing, but the code itself is different. That's what the legal protection means. If the code is different, then we can have exactly the same programs. Which is on one hand good because there is no locking on the business on the market. There is not only one monopoly company which would create one software and then no one else would create the similar software as well. On the other hand, the problem is protection of investment. If someone is the first one creates the software and only the code is protected, then someone else can come and copy the software, the functionality of the software in an exact same way, and then it's okay. It's not copyright infringement, it's not infringement of software law, which is really problematic thing. We are still, as lawyers, trying to balance and find out what's the best solution, because not to fully protect the functionality is a good way, and it's also not a good way to not protect it at all. We don't have any answers. There's this lawyer's joke, ask one lawyer and he will give you 4 different answers, because the law is not giving the similar, simple answer to the questions. It's just creating more and more questions, and we are basically trying to avoid the correct answer, how you should proceed, what you should do, and so on. And this is exactly the problem of the software as well. But the software protection is multi-level. There are a few other things which you can protect. Basically, another question is, what about graphical user interface? How the software is appearing to the user. That's what I mean by that. Again, some judgments at the European Court, at the Czech Court as well, is saying that the look of the interface of the program or of the software cannot be protected in whole. Thus, those economical softwares are basically looking all the same. But what can be protected is if there is author's work. So if someone draws a nice new logo of some button, you know, for example, in Microsoft Office again, if you have this brush to copy a format, this is protected by copyright code. But only just this small picture, for example, or small logo, for example, if there's a logo of the producer. but not the look itself as a whole. That's another problem, another piece of protection. The question could be, if I have a software from someone else, how can I use it? The first point is I have to have a license. I buy a software in a shop, or I make an agreement with someone who created the software, who tells me, yes, you can use the software in this way and that way. If I want to do anything else, or if I want to do anything, I have to have the agreement with the creator. If I don't have it, then I can somehow use the software only in a limited way, which is what I'm describing here in paragraph 66 in, again, copyright act. We are still in the copyright act. The biggest, let's say, interesting thing or legal regulation is that the law is saying you can do reverse engineering of the software. You can basically buy someone else's software and then look at the source code, look at the functionality of the program, how it works. You can copy the functionality again, and then you just write it in a different way, different code, different language. That's okay, that's fine. That's not a copyright infringement. So this is another part, another piece of the puzzle, how the software protection is working. The question still is it really protecting the software as we would like to, as it would be logical in this manner? I don't think so, and again, still trying to find the proper, correct answer how to do that. Another question could be, can a software be patented? The answer under the Czech law, the software itself cannot be patented at all. It's different in US. You know those Apple, Samsung battles about software patents, slides to unlock and so on and so forth. This cannot happen in European Union actually, because there is no software protection in the meaning of patent. What we are able to do is to protect software if it's part of the technical solution. If it's some medical tool which is operated by the software, or the best example would be ABS in a car, then it's a combination of some mechanics and then software who guides the mechanics. Then it can be protected. But if we are talking about Kiwi search engine, for example, then it cannot be protected by the patent at all. It is usually misspoken quite often that the software is patented in Europe and so on and so forth. It's not. That's another piece to the puzzle. Another protections of the software is, of course, going absolutely outside of the Copyright Act. It's possible to be protected as a trade secret on the market. It's possible to be protected as a confidential information on the basis of some contract. And of course, the really strong argument is competition law. If somebody is is copying your functionality, but basically hampering your target on the market, then it could be problem in connection with competition law. But this is really like another tools which are not that strong. The last piece of protection of the software, I didn't implement it in my presentation because it's really complicated. It's misunderstood even by Czech courts, even by European court, and it's a database protection. And that's what you are doing. You are working with the databases. They have really different type of protection. I don't want to go in that, but what I wanted to say that it's another level of protection of the software. So, just a quick mashup. Firstly, you protect software as a literary work. Weird, code, okay, well, that's what we have. Secondly, you can't protect the functionality because locking the market. You can possibly protect it by some agreements, contracts, that's fine. Then there is database protection, and that's all. That's how the software protection works. And in my opinion, it really doesn't reflect the needs of the market, the needs of the producers of the software to protect their investment. That's something like a summary for this part. Then I'm going to the second part. The question was, and I was talking about it a bit, who owns the software? Some of you are employees, right? You are paid for the creation of the software. In this moment, there's pretty easy answer. There is paragraph 58 or section 58 of Copyright Act saying if you are doing it for the employer, if you are paid for it, if it's written in your working contract or employment contract, sorry for that, then it is owned by the company. It is owned by the one who is paying you. It is owned by the employer. The employer then decides what he is going to do with the software, and he's not asking you if he can use it in this way, if he can sell it, if he can do whatever else, if he can change the code you wrote. If you are not doing it on the basis of any contract, if you are doing it for yourself, of course you can decide by your own. This is pretty simple answer, but maybe good to know. And the last part, are you, as a developers, are you using open source software in Kiwi? That's the question. Yes, no, yes. Are you implementing it in into your product? Yes, I suppose. That you take someone else's open source software, you use it and put it in your, for example, part of the search engine or whatever else. Are you checking the licenses if you are able to do that? If the open source license is allowing you to implement it in your product, you should be, or someone should be doing that, because there are, as I'm saying or writing here, there are different types of license. Each license is allowing to do something else. In an easy way, there are three different branches of the licenses. There is the strong copyleft license, GNU-GPL, which allows you to use the software, to modify the software, but it doesn't allow you to sell the software. So if you are using GNU-GPL software and implementing it into yours, the company is doing it for the profit, right? But the license is not allowing to do that. That's one point. What you are able to do for the commercial use is to use permissive licenses in here, which is, for example, BSD license or MIT license. In this case, you are only needed to mention the name of the author, saying that the original piece of software or the code was licensed under BSD MIT license. Me, as another author, modified the software, and then if I'm not using BSD license for the future, I can even implement it in another part which could be sold. But I have to say that, I have to use the original piece, say that this was the BSD license, that's fine, then I modified it, and then I'm not using BSD license anymore because it's saying it's basically free, open, and for especially non-commercial purposes, then I modify it and put it into commercial software. So the point is, well, isn't it a bit complicated? Probably it is. But my point is, you have to have a look on the specific license. If I would show you, the BSD license is basically saying only that. That's all the statement. You know that the license agreements can be for pages and pages, and if you install new software, then you have to scroll down and down and down, and it's pretty massively long. BSD license is only those, I don't know, 8, 9 lines. It's saying only, if you are using open source software licensed under BSD license, then you are supposed to state the author, you are supposed to state that you modified it, and that you are the new author as well. So it's basically accumulating all the authors who are modifying the software. This is my point. BSD license is putting a disclaimer there that you are not responsible for any possible defects. That's my last point, and like a bonus, and I will end soon, like in a minute. The problem with disclaimer is that Czech law in civil code is saying that you cannot state that you are not responsible for something you created. If you are willingly doing some mistakes in the software, then you bet you are responsible for that. If you are doing it unwillingly, then you are not responsible fully, but still partly. If it causes harm to someone else, if it shuts down all the infrastructure of some institution, then you are somehow responsible and then there's this decision-making process at the court to figure out how much you are responsible for that. And basically, this is all. Thank you for your attention, and if you have any questions, please ask me.
Thank you very much. We have first question here, and I will get the sweets.
I'd like to ask, you said we're developing something and we want to protect the thing around, behind. And you said we should write it on paper. But what with the paper? Like we should upload it to a website or where? How? I don't understand.
The habit is if you are, will you give me some sweets as well? Thank you very much. To answer your question, it's necessary to get the ideas somehow on the paper. If the employer, if you're doing it for the employer, if he locks it down to the safe, or if it's somewhere at some shared drive or whatever, that's fine. It doesn't matter where it's put. In the moment, in the future, you will prove that this was the idea, this was what I wrote in the papers, and I want to protect it in this meaning. Then you are getting the papers to the court. That's the reason. You are showing all the idea. It's not only in your mind, but you wrote it somewhere down. You describe how the program works, what's the scheme of the program, and then if there is a problem, basically you just put it to the court or to other party to show and prove how it works. And also it's a good habit that you are not only selling to developing companies only the software, but also the documentation around the software. The company should know, or another scientific institution or whatever should know what are the ideas behind, and that this institution can develop it further. Because from the source code it's not always visible, or maybe never visible. So this is the reasons why you should put it somehow on the paper.
And if I have like a small, so if I have my own startup, let's say, and I have some idea, so I should write it and have it somewhere. And
if it's connected to the software, then yes.
yeah.
The idea is really, if you are writing the software, then you have some other documents which are basically explaining what the software does. It better shows how it works, what were the ideas, what's the purpose, and then if there is a problem or if you want to sell it, it's better to, those materials are better explaining to other party how it works, what it does, and it's better sold by this. And those two pieces, the software and those materials together are comprehended by the Copyright Act as a computer program. So the computer program is not only the code itself, but it's also the documents around. The legal definitions, crazy, I know.
We have another question.
If you use in your program, in your software, software that is licensing and the low-level license, can you the final product license it in higher level than the one that you were using?
I'm sorry, I don't know if I...
You were showing us 3 levels of, let's say, license.
Three different branches of the free open source license.
Yeah, and one is, let's say, less restricted, one higher, one higher.
Yeah.
If you use it, are you using software from the lowest restriction? Can you, your final software, license it in any of the other 2 levels?
Yes, you can. The problem is that there are so many software licenses, those open source, that sometimes they are not just complementary to each other. So in the beginning, you should correctly choose the proper license. If you want to sell it in the future or allow someone to sell it, then this BSD license or MIT license is probably the best to do that. If you are willing, or if you are aiming to have like a viral effect, that you always want your piece of software to be free and to be like spread it around the world, then you should choose the most restrictive license, which is GPL. So again, the answer is not like strict and simple, but you really have to choose. Besides, in the presentation, I have the link. There is the list of the possible licenses. The most common are around 30. and there are hundreds of more, and you still should respect the statement of the licenses and so on if you are using open source software. So it's pretty crazy in the end.
We will share the presentations so you don't have to write down the links. Are there any more questions? Okay. One more speak.
When you say that you are responsible, you have the responsibility under your software, even if you are somebody else is using it later, is any kind of licensing that you can use to, let's say, use under your responsibility or something like that?
All of those licenses are basically saying it's for your own responsibility, but the problem is, I wanted to state it that in the end, you can't get rid of the full responsibility. You are still somehow responsible. It depends, and if you say this is only like a beta version, it's a testing product, then your responsibility, if it causes some harm, is much lower than if you say this is final product. Then if you say it's a final product and you know that there are some problems in the software, then again you are more responsible for causing someone else the harm. So, and what's the amount or what happens then? Then if somebody sues it at the court, the court is basically trying to look what happened. The court can say only, it's enough if you just excuse yourself to the company who caused the whole harm, or you will pay the 50% of the damage, you will pay the full damage. It really depends on the case, what really happened, and then on the capability of the lawyers, of course, at the court, and then hundreds of other situations which can happen, and we can totally twist the whole situation. So, yeah.
Are there any more questions? Okay.
Thank you. Hi. If I remember it right, you mentioned that reverse engineering is not big as well, right? What about software, houses and software itself, which has a license agreement, something like you are not allowed to reverse engineer, something like that?
This paragraph in Copyright Act is, it has to be respected. I don't want to, it's like a cogent regulation, and it cannot be eliminated by any agreement between the parties. So basically, if someone writes it down to the contract, then it's not valid.
Okay, and what about scenario that I would not want to agree with the agreement? Actually, I don't want to use the product, but I just want to reverse engineer it. Is it okay?
If you gain the original product in a legal way, then you can do the reverse engineering. You can gain it in some other way than buying the product from the company. You can basically buy it from a friend or from someone else. But the point is you can't download it from some file share server because exactly in the moment you start the download, you are infringing the law. And everything what happens next then is under the regime of infringing the law. So, the end. Yeah.
Thank you very much. Do you have some other questions?
May I ask you a question? I missed the part, if the license is not provided together with source code, so is there any protection?
You mean if I'm buying the software or
if the software is distributed without
if there's not any license, the license agreement by the law is defined that it can be oral or it can be given just by some behavior. So if someone gives you the software and tells you on the street, use it as you wish, then you have a license agreement. If the software doesn't show any license, then it's only for you, it's then harder to prove what were the conditions you can use the software. So if the software does not have any license around, it doesn't mean you are not allowed to use it. It just means that it's much harder to prove that you are still somehow allowed to use it. And if you find the software somewhere on the internet without anything else, then you should use it only for the studies, probably, but you should not sell it, because again, if there is no license, like direct license, then the law is saying there is only not exclusive license to do it, and usually it should be for non-commercial uses.
Thank you. Okay. Any other questions?
I would like to ask you, you said that the source code is protected by the law, like a book, for instance, or literary work. What amount of the source code must be disclosed to be taken or viewed as infringement? How many lines of the code must be put away and misused so that one lawyer can say that it was an infringement, 1 line or 10 lines, 10,000 lines? It's a very interesting question because if you take one line of code beginning with if command, it's a part of it work and it's been stolen.
Thank you for the question. I'm really glad you asked, because this is really the problem of the software protection as a literary work. The answer, I would say my strict, clear answer, I don't know, because no one answered that. The courts were deciding different cases. Sometimes the infringement was only for like 10 words. Sometimes the infringement wasn't found out even if it was like 10 lines. So it really depends what piece of software is, how the sentence, how the code is unique. That's what we are talking about. And it depends on the case-by-case basis. For example, a bit different but still similar case to that, the Google was sued 8 years ago that when you search something, then there is this showing up what is in the page. You know, there's a link, there's a page, and then there's a hint of the text, what's actually on the page. But the author of the page originally didn't give the permission to reveal that. And the case was really about, are 3 lines enough to infringe the copyright or not? And in this case, the court said, yes, they are, because Google is doing it automatically, it's doing it all the time, and we can't process each link, because sometimes it would be 5 words, sometimes it wouldn't be a whole page, but we can't process it. So in general, even 3 lines are infringement, and if it's automatic, then it's like more strict legal rules apply to the situation. So in the end, you should be aware that you shouldn't be copying, obviously, but in the end, it's always hard to prove if your source code was that original, that those 3 lines are unique and no one else could use it, no one else could invent it in the same manner. Because the computer language is somehow limited. It's like physical laws. That's I don't know if you know Lawrence Lessig, but he was basically saying that the code is something like a physical law for the internet, and it's working only in some ways, and it's limited. So we can only move in specific area, and there's always somehow limited scenario how you can approach to the solution. And this is all the arguments which were dealt by the courts, and thus there is no clear answer because it depends on case-by-case basis.
Okay, so thank you. Our speakers will be staying here, so maybe you can later have a drink with them and ask other questions. So thank you again, Pavel.